Hello, my name is Orrin Hill. I am the legal counsel for the Nebraska Public Employees Retirement Systems, or NPERS. With me today is Vanessa Holland, the NPERS internal auditor. We're here today to talk about LB 147, a bill that impacted what it means to terminate employment for retirement purposes. Now that the new law has been in effect for about a year, we want to take the opportunity to share what we have learned with you. This should help you ensure you are properly implementing the law. Today, we are going to discuss 4 topics. First, we're going to review the rules and why they are a good thing for schools. Second, we're going to identify some of the most common pitfalls and stumbling blocks NPERS has observed over the past year. Third, provide responses to common questions and concerns. And fourth, review helpful tools NPERS has developed that should help you and your fellow employees implement LB 147. Both federal and state law governs the retirement systems. We must ensure all provisions of law are followed to protect the favorable tax treatment of your retirement benefits and ensure your benefit is there when you need it. However, you, as reporting agents and plan members, play a vital role in ensuring compliance with these rules. You are our eyes and ears in the field. We rely upon your knowledge and expertise. This slide summarizes the 4 major components of the school plan's termination of employment rules. First, before a plan member can stop participating in the school plan and/or take a distribution from retirement, the member must experience a termination of employment. This means the member must have a bona fide separation of service from all employers covered by the school plan. Generally, to have a bona fide separation of service for retirement purposes, a terminating employee is prohibited from rendering any service to any employer covered by the school plan during the 180 days following the alleged termination date. However, LB 147 specified that a plan member is deemed to have terminated employment if the member renders no more than 8 days of intermittent voluntary or substitute service per calendar month during the 180 days following an alleged termination date. So long as the plan member adheres to these requirements, the member will be deemed to have terminated employment for retirement purposes. This means neither the member nor employer are required to contribute to the retirement plan, and the member may take a distribution from retirement. If the member or employer violates these strict rules, both the member and employer must fix the violation. This means both the member and employer must make up missed retirement contributions. The employer will be subject to late fees and interest for failure to timely report the compensation, contributions, and service hours, and the member will be required to repay any distributions taken from retirement and may face tax consequences. Finally, the employer must submit a new non-contributing member form establishing a new termination date for the member, and the member must restart a new 180-day termination period. It is important to note that these rules apply to all terminations of employment, not just retirements or when a member takes a distribution. Those events merely add more consequences that must be addressed when there is a violation. A lot of long-standing reporting agents remember the old once in, always in rule. One of the oldest versions of this rule said that once a member is in the plan, that person is always in the plan at all employers for all types of employment. That rule has been pared down over the years to help schools address the issue of finding substitutes. Examples of bills that curtailed this rule include, but are not limited to, LB 538 from 1999, which helped differentiate substitute service from regular service, LB 407 from 2001, which further defined substitute employee to account for permanent substitutes or floater-style positions, LB 263 from 2013, which modified the law to require employees to establish eligibility at each school plan covered employer independently, and of course, LB 147. Now you should be focusing on whether the employee is a regular employee, substitute employee, temporary employee, or other employee for retirement purposes to determine what rules apply. Please remember that these categories of employees have specific statutory definitions unique to the retirement system that likely do not match up with the common definitions used in the education community. So I have been asked, why is LB 147 a good thing if it imposes more rules we have to monitor and follow? In short, this is because schools asked for it. Schools have been and continue to be in dire straits to find substitutes to cover classrooms. The COVID-19 pandemic only made things worse. The old law was vague and didn't provide schools, members, or NPERS clear guidance on how much intermittent voluntary or substitute service was too much. Thus, to protect the plan's tax-preferred status, NPERS followed general IRS guidance and advised plan members to only provide sporadic, unplanned substitute service and generally advised no more than 3 to 4 days of substitute service during the 180 days following termination. That being said, we understand the school's need. So we worked with the schools and the Retirement Systems Committee of the Legislature to address the issue. The legislature listened to the concerns of all stakeholders and considered the federal rules, such as how the IRS looks at the facts and circumstances of each termination of employment, and the guidance offered in IRS private letter rulings. Ultimately, the legislature decided to allow up to 8 days of intermittent voluntary or substitute service in each calendar month during the 180-day period following termination. This doubled the number of intermittent volunteer or substitute days per calendar month a member could work from the standard NPERS had previously recommended. The schools and unions were happy with this change since it addressed the school's need for substitutes and the union's desire to have a bright line rule they could tell their members. NPERS felt we could maintain the plan's qualified status so long as we were given specific authority to enforce the new standard and spending authority for an additional auditor to help with enforcement. The legislature granted both of these to NPERS. Thus, LB 147 ended up being a win for the schools because they got greater access to an excellent pool of substitutes, a win for the unions, members, and NPERS because there is now a bright line rule that we can all follow. At this point, I'm going to turn things over to Vanessa to discuss what the NPERS Internal Audit Department has seen with regards to LB 147 during the past year or so.
The next slides will go over the majority of issues we are currently seeing in audits regarding LB 147. Before going through the individual circumstances, I want to reiterate a couple of the things that Orrin discussed. Remember that LB 147 applies to all member terminations and not just retirements. Anytime you have a member terminate from the regular and ongoing position, you need to follow the steps listed on slide 3 to include not having a prearranged return to service. With that being said, when the member terminates from any regular and ongoing position with your school or ESU, participation in the plan must stop. As limited substitute and volunteer service is the only thing allowed after termination during the 180-day separation period, it is imperative to ensure the guidelines are followed. All substitute and volunteer service rendered following termination must be tracked. With that being said, if the person is rehired, you must also follow the separate steps for reemployment. But before we go any further, we need to remember that substitute service is clearly defined in statute and has a very narrow focus. A substitute for retirement purposes is defined by statute as a temporary employee filling in for a permanent employee who is temporarily absent. Substitutes are not eligible to participate in the plan. If you have someone that you classify as a substitute, but they are filling in for a vacant position or training in the office to be able to provide substitute service for the office staff, that is not substitute service for retirement purposes, and it would be an immediate violation. For LB 147, the Internal Audit Department was given the authority to hire an additional auditor to test compliance. NPERS has added a test within our current school audits to determine compliance with each individual school, but we will also start current testing across the board for terminations and retirements, along with their subsequent substitute and volunteer service during that 180-day separation period. Now, to go through the 3 most common violations we are seeing when we audit the terminating and retiring members along with their subsequent 180-day separation period. The first scenario we see is when the member follows the termination rules, but the employer improperly reports. So the member terminates their regular and ongoing position and provides only substitute and/or volunteer service, not to exceed the 8 days a month during the 180-day period, and the employer does not discontinue participation in the retirement plan. Reporting of compensation, contributions, and service credit should have stopped immediately upon termination. Without a violation of the rules, an adjustment form would need to be submitted for all compensation, contributions, and service hours reported after termination from their regular employment. The employee could substitute without limits as soon as that 180-day separation period is over. The next situation we see is when the member eventually violates the termination rules and the employer improperly reports. So the member terminates their regular and ongoing position, and the employer never discontinues participation in the retirement plan. The member only provides substitute service, not to exceed the 8 days a month, until, let's say, month 5 of the 180-day separation period, when they then render 9 days of substitute service. Upon termination, the employer should have stopped all reporting of compensation, contributions, and service hours to NPERS. Only after a violation has occurred should the employer report the compensation, contributions, and service hours from termination to the violation date. Because there was a violation in month 5, a new 180-day separation period will need to be established. To do this, the employer must take a full look at all substitute and volunteer service rendered from the initial termination to current and establish when the last violation occurred. At this point, nothing should be reported to NPERS, and tracking must continue to confirm no more than 8 days of substitute or volunteer service is rendered during the new 180-day separation period. Keep in mind that NPERS will also look at what your documentation says. If the school wants to reclassify this employee as a permanent employee, allowing participation in the plan, then they must have the documentation to support that. All NPERS can do is look at the laws that govern the retirement plan, look at your processes and employees, and verify whether or not the school's processes and employees are compliant. Now here is the scenario that can get a member into some trouble. This scenario keeps NPERS out of the loop and will not stop us from processing a distribution when a member does not meet the requirements for a bona fide termination. In this case, the member violates the termination rules, and the employer never reports the violation or correct compensation, contributions, and service credit. With this situation, the member works 9 days of substitute service, immediately violating the termination rules. But the employer fills out a non-contributing member form, discontinued retirement, and no compensation, contributions, or service hours were reported. The problem with this scenario is that if the member requests a distribution, NPERS has no way of knowing that the violation occurred. Further, if the member receives a distribution, the member would have to pay back the distribution to include any late fees, fines, penalties, and/or interest. At the very least, as soon as a violation occurs, an adjustment form needs to be submitted to report all the compensation, contributions, and service hours from termination to the date of violation. A new 180-day separation period must be established, and tracking of all substitute and/or volunteer service must start over. Keep in mind that LB 147 is based on the member's substitute and volunteer service at all employers under the school plan. It is the employer's duty to provide as much education to the member as possible. Failure to follow the rules can result in audit findings from both NPERS and the APA. Members will have the incorrect compensation, contributions, and service credit reported, which could drastically affect their final benefit. Adjustments will need to be submitted to correct the errors, and missed contributions will need to be made up, along with any late fees, fines, penalties, or interest. These errors can cause significant delays in and prevention of a member's retirement benefit or distribution, as well as requiring a repayment of a distribution.
Thank you, Vanessa. Now that we have seen some high-level examples of the most common errors Vanessa and her team have seen over the last year, we are going to discuss in detail a specific example that occurred in March of 2022. This example should help show you how improper application of the termination of employment rules can lead to a lot of extra work for both you, the plan members, and NPERS staff. We know how busy you are and want to minimize your work to the best of our ability. Thus, we hope that by showing you the examples, you will be better positioned to respond if something similar comes across your desk. This slide shows a fairly standard termination of employment process, with the member terminating and the employer filing a non-contributing member form, or non-con, documenting the termination. Several months after the alleged termination date, the member asked to receive an estimate of retirement benefits. The NPERS Benefits Department reviewed the member's account. This slide shows service hours and wages reported to NPERS after the alleged termination date listed on the non-con. This was out of the ordinary, and at least implied that the member may not have terminated. Naturally, NPERS asked questions when the information reported by the member and employer didn't align, but more so because the information provided by the employer seemed contradictory. This slide lists some of the questions the NPERS Benefits Department asked the employer on or about March 11th of 2022. Answering these questions is exceptionally important so that we don't unlawfully distribute retirement benefits. Ultimately, NPERS needed to determine whether the member had terminated and was now only rendering substitute service, or if the member had not terminated and was now a part-time regular employee. This slide shows the answers the employer timely provided. Of particular concern to NPERS was the employer's reference to the old once in, always in phraseology, since, as we have previously discussed, there have been multiple amendments to the law over the years that have whittled away at that position. Naturally, NPERS continued to question the employer's response. To help better explain our concerns, we prepared the table on the next slide. NPERS plotted out the number of alleged intermittent substitute days the member rendered in each calendar month since the member's alleged termination date based on the hours reported by the school district and the explanations the school district provided. After looking at the data, we had more questions and identified our concerns with each month. October 2021 was our first major concern. It appeared the member and employer had violated the termination of employment rules that were adopted under LB 147, since it appeared the member worked more than 8 days in that calendar month. If a violation had occurred, then there were also concerns about December 2021 and February 2022, since the member's termination date would change and a new 180-day period would be established. As part of our inquiry, NPERS contacted the member to discuss their intention and understanding. The member told NPERS the intention was to terminate at the end of May 2021 and substitute no more than 2 days per week to comply with the termination of employment rules. We followed up with the employer asking several more detailed questions. You can see them on this slide. Again, the employer was very timely in their response. They provided a responsive spreadsheet which included more information on March 15, 2022. However, there were still discrepancies between what information that was initially reported showed versus the data in the spreadsheet and the employer responses to our questions. Because NPERS could not find a way to reconcile the discrepancies, we were left with a difficult position of asking to which errors does the employer want to admit. Here you can see the dilemma that both NPERS and the employer faced. Under option 1, the member did not terminate, but only had a reduction of hours. In this case, the employer improperly submitted the non-con and properly reported the compensation contributions and hours. Under option 2, the member terminated and only performed substitute service during the 180 days following termination. In this case, the employer properly submitted the non-con, but improperly reported the compensation contributions and hours before the member violated the termination of employment rules, and the employer miscounted the number of substitute days in each month. If option 1 is true, then the employer would need to submit a new non-con changing the member's termination date. If option 2 is true, the employer improperly reported substitute wages and hours, and those errors would need to be corrected so NPERS can properly calculate the member's benefit. Now to the ultimate resolution of the case. NPERS asked the employer to plot out the member's intermittent substitute days on a calendar and list on each day for whom the member subbed. The employer complied and submitted the information. They also noted that their pay periods do not align with the calendar month and that this could explain why some months showed high hours while other months showed lower hours. After verifying that the member had not subbed for more than 8 days in any calendar month following the alleged termination date in May 2021, the employer admitted they should not have reported any of the compensation contributions and hours in August of 2021 forward and agreed to do an adjustment to correct the error. Now Vanessa is going to discuss some of the tools NPERS has developed to help you comply with the rules and avoid making similar mistakes.
There are several tools we have made available to assist you in complying with all the laws that govern the retirement systems, as well as to hopefully make your jobs a little easier. For frequently asked questions pertaining to LB 147, you can locate the FAQ on our website. The calculator tool was made specifically to help employers monitor employees that do not meet that initial eligibility hour requirement and takes the guessing game out of how to determine if employees met the hours threshold by working an average of 20 hours a week for any 3 calendar months of the fiscal year. This tool lines up the fiscal year used in statute and uses the exact formula that NPERS uses in determining the average number of weekly hours in a calendar month. You can also locate templates for substitute logs and extra duty logs on our website.
Thank you, Vanessa. Lastly, we want to discuss some extra material that falls outside LB 147, but it relates to legislation passed this year in 2022. LB 700 was passed this year with the emergency clause in effect, which means it went into effect the day after the governor signed it. While it shouldn't have a large effect on your work, it is important for you to know. First, LB 700 clarified that the rules for state employees that participate in the school plan while working for NDE, DHHS, DCS, or other state agencies in a certificated position. Second, and probably more important to you, is the changes LB 700 made to the NPERS education program. NPERS asked and the legislature approved changes to our program so we can provide better information to members of all ages rather than providing specific instruction to members under age 50 and different instruction to members over age 50. Additionally, we asked to be able to provide more online educational materials and seminars. This should help your workload since you could refer your fellow employees to our website for online resources and should help your fellow employees get more education outside their normal workday. Please keep in mind that school employees have 2 statutory paid days off in addition to any other leave they may be granted for retirement education. However, the new law under LB 700 clarifies that the leave can only be used for in-person or live webinar events that occur during the employee's regularly scheduled workday. The leave cannot be used when the member is merely watching videos or reviewing materials that are available at all times on the website. On behalf of NPERS, Vanessa and I would like to thank you for watching this video. We know how busy you are and that retirement is only one small part of all that you do. However, we feel it is an important part since it is a great recruiting and retention tool and is a great way to take care of our retired educators. Please reach out to NPERS Employer Reporting Department or our Internal Audit Department if you have questions about the retirement system. We, like you, always prefer to take a little time up front to avoid taking more time to fix errors on the back end. Thank you again for all that you do and have a great day.